Ready, start. Section 218-223 CRPC make it clear that distinct close offenses refer to unconnected or independent acts. In the present case, the alleged conspiracy links the appellant with the co-accused, making separate trials legally impermissible. It was argued that segregation would enable the prosecution to tailor its evidence based on prior cross-examination, thereby causing serious prejudice to the appellant as well as the co-accused. It would also expose the appellant to multiple proceedings for the same transaction in violation of Article 20 (2) of the Constitution protection against double jeopardy and the fundamental right to a fair trial under Article 21. Finally, it was submitted that neither delay in the appearance of co-accused nor the desire for expeditious trial provides lawful justification for segregation. The Code of Criminal Procedure permits separate trials only in exceptional circumstances, such as the absconding of co-accused or the existence of distinct transactions, conditions that are absent in the present case. On these grounds, it was prayed that the impugned orders of the trial court and the High Court be set aside and a direction be issued for a joint trial of the appellant along with the co-accused in accordance with law. Per contra, the learned counsel for the respondent opposed the appeals and submitted that the appellant challenges the legality of the orders dated 28/8/2024 and 2/9/2024 passed by the trial court in session cases arising out of FIR numbers 150 and 149 of 2023 respectively. By these orders, the trial court directed the station house officer to file a separate charge sheet against the appellant, who is a sitting MLA, and accordingly segregated his trial from that of the co-accused. In compliance, separate charge sheets were filed against the appellant. Charges were framed on 25/11/2024 and the prosecution has already commenced evidence with several witnesses having been examined. It was contended that the segregation of the appellant's trial was necessitated to ensure judicial efficiency, as the presence of 43 accused in FIR number 149 and 28 accused in FIR number 150 had rendered the conduct of a joint trial logistically and procedurally cumbersome. Repeated non-appearance of certain co-accused had already resulted in considerable delay. Learned counsel submitted that the segregation was intended to prevent further delay in proceedings and in fact facilitates early disposal. The measure does not in any manner prejudice the appellant's rights. It was further argued that under Section 218 CRPC, the general rule is that each offence shall be tried separately, while Section 223 enables joint trials. It is couched in discretionary terms and must be applied only in appropriate cases depending on the circumstances. Reliance was placed on Naseeb Singh versus State (Supra), where this court held that test for permitting a joint trial includes consideration of whether it would prejudice the accused or cause delay in the proceedings. In the present case, appellant failed to establish any real or specific prejudice arising out of the separate trial. Further reliance was placed on Ashwani Kumar Upadhyay,